Hi, I'm John Harris, founder of Citizens for Justice with Mercy. Today I want to talk to you about the very unfortunate, even tragic death of Ahmaud Arbery at the hands of two gentlemen who thought they were trying to make a citizen's arrest. The McMichaels, father and son, saw Mr. Arbery leaving a property that was vacant and assumed that he burglarized it. He was running away. They got their little posse together with guns and a video, and they cut him off at the pass. The younger of the McMichaels was standing out with a shotgun, blocking Arbery's way. He tries to go around the truck and is eventually assaulted by Mr. McMichaels and shot. Now, they will argue that he did reach up and try to grab the shotgun. He tried to take the shotgun, and they all want to talk about whether or not this was self-defense. I want to tell you that the big internet fight that's raging right now about whether or not he could be arrested by citizens is completely irrelevant. What is relevant is whether or not the McMichaels could use deadly force in that arrest. And the answer in Georgia law is absolutely not. Now, I want to tell you, I'm not a lawyer. I do work in law. I'm a paralegal. But I'm not giving legal advice here. I'm giving you my opinion on what Georgia law says. Please, the cool part about law is that it's written down and available to you. Go look it up. Individuals have a right to use deadly force on very narrow reasons. If you look in Title 16, Chapter 3, 21, 23, and 24, you will see the times where a citizen is authorized to use force and even deadly force. 21 is the defense of self and others. It says in the deadly force section, the use of force which is intended or likely to cause death or great bodily harm to prevent trespass on or other tortious or criminal interference with real property other than a habitation or personal property is not justified unless the person using such force reasonably believes that it is necessary to prevent the commission of a forcible felony. Now let's think about this. Mr. Arbery was no longer around any of the personal property or the real property. And nobody thinks that he was about to commit a forcible felony like armed robbery or rape or murder or some other sort of forcible assault. You might say, well, he tried to reach and grab the shotgun. That's a forcible felony. He was assaulting Mr. McMichaels. Yes, but after Mr. McMichaels used or threatened to use deadly force on him. So Mr. McMichaels was the one who was aggressing. Let's take a look at the second statute. 16.323 is defense of habitation. A person is justified in threatening or using force against another when and to the extent that he or she reasonably believes that such threat of force is necessary to prevent or terminate such other's unlawful entry into or attack upon a habitation. Now we can see right away that this doesn't apply because he wasn't trying to get in and he had already terminated his entry into this habitation. Let's look at section 24, 16.324, defense of property. A person is justified in threatening or using force against another when and to the extent that he reasonably believes that such force is necessary to prevent or terminate such other's trespass on or tortious or criminal interference with real property other than the habitation or personal property of his own. Again, nothing in that section applies to the McMichaels or Mr. Arbery. This is very simple. The McMichaels decided to play Wyatt Earp. They wanted to get their guns and go arrest this guy because they had reasonable suspicion that he was doing something wrong. I don't want to argue about whether or not their suspicion was reasonable. Let's give them that. They cut him off at the pass. They're standing out in the middle of the road, or at least the son was, standing out in the middle of the road with a shotgun, blocking Ahmaud's way. Ahmaud doesn't run straight up to him. He goes around to the right of the truck. And the younger McMichaels comes in front of the truck to again cut off Ahmaud with a gun. That is the threat of deadly force. Yes, Ahmaud charged him and tried to take the shotgun, but honestly, once he's being attacked, Ahmaud had the self-defense right. Ahmaud has the right to use force. These gentlemen had no right to use deadly force in trying to arrest or question or whatever they were trying to do to Mr. Ahmaud Arbery. Unfortunately, their aggravated assault, which is what you call an assault with a deadly weapon, ended up in the death of Mr. Arbery, and a death in the commission of a felony is felony murder. Now again, I'm not an attorney, but that is my opinion. And in my opinion, while I am completely for the Second Amendment, while I am completely for protecting your property and using your weapons if someone is attacking you, we are not in the Old West. You cannot form a posse and hunt someone down. And if you do, there's a strict liability. If you kill them and you're wrong, you're in some deep trouble. I invite you to comment down below. And if you want to change the justice system in the state of Georgia and in the nation, please join us. Join this YouTube group and go find us on Facebook, Citizens for Justice with Mercy. I'll see you there.